Christian Louboutin has been handed a win from the European Union's highest court in its latest battle over the red sole. Shortly after the lawsuit that the Paris-based footwear brand initiated against Yves Saint Laurent in a New York federal court came to a close, Louboutin, which is famous for its Chinese red shoe soles, initiated a long thick-ish running dispute with Van Haren, after the Dutch footwear brand launched a collection of high-heeled footwear, entitled Fifth Avenue by Halle Berry, in 2012, featuring red soles, up for debate whether Louboutin maintains trademark rights on its famous red shoe sole. In April 2013, the District Court of The Hague awarded Louboutin a preliminary injunction, ordering Van Haren to immediately cease its manufacturing and selling of black and blue shoes bearing red soles, and to pay Louboutin's court costs and legal fees. Van Haren appealed this decision and the Court of Appeals referred the case to the Court of Justice of the European Union, CJEU, the EU's highest court, to determine whether Louboutin's trademark is valid. That is how the case ended up before CJEU's Zag Spooner, who held almost exactly a year ago that Louboutin's red sole mark qualifies as a shape mark, or a mark consisting of the shape of the goods and seeking protection for a color in relation to that shape. He further held that the European Trademark Directive could, in fact, apply to and protect a shape in combination with a color, in this case, high heels and bright red. However, what went unanswered was whether such protection applied to Louboutin. On Tuesday, Louboutin got its answer, with the CJEU panel holding that its red sole is not prohibited from trademark protection, according to European Union trademark law, namely Article 3(1)(e) of Directive 2008/95. Faced with determining whether Louboutin's red sole amounts to a shape mark that gives substantial value to the goods, and thus, should not be registered as a trademark, the CJEU panel held that in accordance with the usual meaning of the concept of shape, which is understood to mean a set of lines or contours that outline the product concerned, a color, without an outline, does not constitute shape. The panel went on to state that, as it has been observed by the German, French and United Kingdom governments, as well as by the European Commission, the trademark at issue does not relate to a specific shape of sole for high-heeled shoes. Instead, the CJEU panel states, the description of the red sole trademark explicitly states that the contour of the shoe does not form part of the mark and is intended purely to show the positioning of the red color covered by the registration. In any event, the panel continues, a sign cannot be regarded as consisting exclusively of a shape, where, as in the present instance, the main element of that sign is a specific color designated by an internationally recognized identification code. Now, with the CJEU's decision in mind, the case will be remanded back to the District Court of The Hague for further determinations, and potentially, the Hague Appeal Court, should Van Haren choose to appeal.